Does living in a house for 12 years make it yours? Here's what the Supreme Court said about adverse possession. Just imagine. You've been living in a house for years, breathing its air day and night, creating memories in every corner. And one day, someone comes and tells you that the house isn't yours. How would that feel? In India, there's an old saying, if someone lives in a place for 12 years, it becomes theirs. But is that really true? Does simply living in a house or on a piece of land for 12 years make it legally yours? Or is this just a widespread legal myth that has been passed down through generations? Today's story uncovers the truth behind this misconception and explains what the Supreme Court has said to clear all confusion. In fact, the concept of adverse possession is very old in India. Its roots go back to the British era, when courts ruled that people who had been in long, continuous possession of a property, while the original owners remained inactive, could gain ownership rights. The intention of the law was not to reward cunning individuals who grabbed someone else's property, but to ensure that land didn't remain vacant or unused. Over time, however, this law began to be misunderstood. People started believing that anyone who stayed on a property for 12 years automatically became its owner. But the reality is completely different. Adverse possession means possession that is unauthorized, open, and continuous. In other words, you occupy someone's land or house without their permission, and the actual owner does not try to remove you or assert their ownership for 12 continuous years. However, this applies only when your possession is genuinely illegal and hostile to the real owner's interest. If you enter the property with permission, as a tenant, relative, or caretaker, then no matter how long you stay, even 50 years, you can never become the owner. Indian law defines this under Section 65 of the Limitation Act, 1963. It clearly states that if a person occupies a piece of land without permission for 12 continuous years and the rightful owner does not take any action during that period, then the occupant may acquire certain rights over it. However, the conditions are extremely strict. The possession must be open, continuous, and known to the actual owner. Simply living secretly or without confrontation does not create ownership rights. And this is where the long-standing misunderstanding began, the myth that spread across villages and cities. Live for 12 years, and the house becomes yours. But the Supreme Court has repeatedly clarified in its judgments, the law does not reward deceit. The first major ruling came in 1995 in the case of Vidya Devi versus Prem Prakash. The dispute involved a piece of jointly owned land. After Raghunath's death, his land was divided into 3 parts, between his widow Vidya Devi and their 2 sons. When Vidya Devi filed a petition suit, one of the sons, Prem Prakash, argued, "I've been in sole possession of this land since 1953. It's been more than 12 years, so now it belongs to me." The court heard his argument, but the verdict was completely different. The bench of Justices Venkatachla and Sagir Ahmed ruled, a co-owner's possession is considered permissive. He cannot become the absolute owner by excluding the others. In other words, if you live on property that belongs to your family or a partnership, your own share remains intact, but you cannot extinguish the rights of the others. The court further said that an adverse possession claim can arise only when the possession is hostile, not when it's based on family ties or permission. This judgment made one thing crystal clear. If someone lives on joint family land or shared property, merely staying there for a long time does not grant ownership. You must prove that you have explicitly excluded others, denied their rights, and that they did not challenge your possession. Then came the second landmark judgment in 1997, Balwant Singh versus Daulat Singh. This too was a dispute between 2 brothers over land. Balwant claimed that he had been in sole possession for 15 years and had thus become the owner under adverse possession. But the Supreme Court rejected his argument firmly, stating, simply living alone or cultivating the land doesn't make possession adverse. If you are a co-owner, You must prove that you have ousted your brother, that you have ended his ownership rights, and done so publicly in a way that others can recognize. The court stated, possession becomes adverse only when you clearly oust the true owner and he knowingly remains silent. Silence and consent are not the same. If the owner trusted you to take care of the property and you took advantage of that trust, the law will not protect you. The third, and perhaps the most important, judgment came in 2008 in the case of 𝐮𝐩𝐿𝐵 versus 𝐵𝐵. In this case, a man named 𝐮𝐻 had been running a shop for 30 years. There was no written agreement, but he paid rent every month. When the landlord asked for the shop back, 𝐻𝐻 claimed, "I've been here for decades. I'm now the owner by adverse possession." The Supreme Court called this a misinterpretation of the law and ruled, a tenant's possession is always permission-based, whether there's a written agreement or not. As long as the landlord's permission exists, the possession is valid, but it never grants ownership. Following this decision, the court also observed that adverse possession in India is being misused. It clarified, this law is not meant to punish the true owner, but to warn those who remain negligent for years. If you ignore your property, someone else may use it, but that doesn't mean they become its legal owner. Now think about how many times you've heard someone say, "Live there for 12 years, and the house will be yours." But that's only a half-truth. The courts have repeatedly emphasized that possession must be hostile, clear, continuous, and open. In other words, you must have openly challenged the owner, declared that this is mine now, and the owner must have failed to take any legal action. Only then could such a claim even be considered. However, living as a tenant, servant, relative, or friend can never qualify as adverse possession. Even if the owner moves abroad and you continue living in the house for 20 years, you cannot become the owner unless the property is transferred to you through a written or legal document. This raises an important question. If living without an agreement doesn't create ownership, can it be risky? The answer is yes. If you live on someone else's property without a written contract, disputes can arise at any time. You'll have no proof that you paid rent or under what conditions you stayed there. In such cases, courts almost always rule in favor of the property owner. That's why lawyers always advise, before occupying any property, there must be a written agreement or rent receipt to protect your rights. The Supreme Court made another interesting observation in its 2008 judgment. Adverse possession now needs to be re-examined. The court noted that this law was inherited from the British era, a time when land ownership and tenancy rights were designed to protect the weak against powerful landlords. But in today's India, where almost every property is registered and legal systems are far stronger, this doctrine is often used merely to create disputes rather than resolve them. In many such cases, the courts have also noticed people producing false witnesses, fake documents, and even old electricity bills as evidence to show that they have been continuously living on a property. But the Supreme Court clarified, electricity or water bills are not sufficient proof of possession. They only show residence, not ownership. Here's another crucial point. What if someone has been living on government land for 12 years? Does it become theirs? The answer is absolutely not. Adverse possession does not apply to government property. The Supreme Court has clearly stated, government land can never be claimed through adverse possession. No matter how many years someone occupies it, it will always remain the property of the state. So now it's clear, living on a property for 12 years only means you've lived there. It doesn't make you the owner. Ownership is granted only when you have legal documents, such as a registered deed, a valid will, or a court order. Without these, your stay is merely temporary possession, which can be terminated at any time.
If our video has taught you something new, do not forget to like and share this video so that this information can reach others as well. Your likes and shares are a source of inspiration for us. If you have any questions or suggestions, please let us know in the comments. It will be our honor to answer your questions and listen to suggestions. And yes, if you like our content, subscribe to the channel and press the bell icon so that you stay connected with every new story. Thank you. GRT Business YouTube channel sources: news from various news agencies, opinion polls, and other public sources. We try to ensure that every report and summary is accurate and verified, but we are not responsible for any dispute or error. Our aim is only to provide you with accurate information.